And this is consistent with what we have been doing. And this language mirrors very closely our current policy, 6.17. Questions on IIAB? Okay. Next policy is GCQA, non-school employment by staff members. This policy is quite similar to what our previous policy, 8.58, had been. The part that was not included in this policy that was in 8.58 is included in our conflicts of interest policy, GAH. Any questions about policy GCQA? Next is policy GCBD. This is staff leaves and absences. This would replace our current policy 8.78. And it is our hope that over the course of the summer, we can bring to you some of the other policies and regulations, or bring all of the regulations that we have up in line with the VSBA model policies, and make sure that we don't have so many. I think right now we have 13 different regulations and a few policies that do cover staff leaves and absences. At the meeting in June, you all did adopt the Family Medical Leave Act policy. So this is working towards getting all of the personnel policies up to date and consistent with the VSBA model policies. Any questions on GCBD? Okay. Policy GCBEA, leave without pay. This policy is different than what our previous regulation had been in some regards, but is fully consistent with required law. And this covers just that short period of time for staff members who would otherwise be eligible for FMLA or family medical leave prior to them completing 12 months of service. It does require that the employees obtain approval prior to taking leave, which we do think is going to be important for us managing having substitutes available, and it also references the policies that the board has already adopted on the military leave and benefits. Any questions on GCBEA? All right. The last policy for the evening is GA. This policy, there were a number of questions at the last board meeting. Previously, the board had adopted GA, and then there were changes to the Virginia Code at 22.179.8, which is referenced down at the bottom, that incorporated the ESSA, which is the new federal law for No Child Left Behind. So while our policy previously had just been those lines 4 through 6, now we're proposing adding lines 8 through 30. At the meeting in June, someone had asked whether we could change line 9 to say that current employees, contractors, and agents of the school board may not assist a current or former school board employee in obtaining a new job if. I did have a chance to speak with Elizabeth Ewing at the VSBA on that. She and I both agree that this goes further than the law requires, but is certainly within the board's purview if you all wanted to add the language current or former. So I have added that in red at line 9 if that's the will of the board. I do think that that makes sense. This is the situation where a staff member has probable cause to believe that the former member or the current school board employee has engaged in sexual misconduct with a minor or with a student in violation of the law. So I want to get to that piece about probable cause, but as it relates to current school board employees or former school board employees, I think it'd be fine to make that clarification at line 9. As far as the use of the phrase probable cause, that is a little disconcerting. It's a criminal law term. It's a term that even lawyers would want to look up what is the case law and what are the requirements there. But the phrase probable cause comes directly from ESSA at the 20 U.S.C. 7926, and then is incorporated also into the Virginia Code at 22.1 79.8. And I do think that it makes sense to keep probable cause as the standard. It's a higher standard, so it protects the school board more. So you'd have to really know that something had happened in order to prohibit any employee, or contractor, or agent from giving a recommendation for a new job. From the dais at the last school board meeting, there'd been a discussion of should we make that word a little bit more user-friendly, say reasonable suspicion or reason to believe, because that's a lower standard. I think that makes it more difficult for the board and doesn't protect the board, because how do we know what all of our staff members might have reason to believe or not? At the same time, as part of my annual training of staff, I share, I talk about the mandatory reporting requirements, I talk about grooming behaviors, things to look out for, what we can do to protect our students. So I think one way to strike the balance of using the term probable cause here would be for me to include in my annual training that if anyone has any reason to believe that any staff member has engaged in sexual misconduct with any of our students or with any juveniles or with any minors, they need to immediately let CPS know or let their supervisor know, who's then required under mandatory reporting laws to report that. It's challenging because the language that's used here at lines 12, 13, and 14 isn't the same language that's used for mandatory reporting, but I think we could handle that in training by making sure staff knows that we are here to protect our students above all else, and that's covered in mandatory reporting, which is part of our policies and part of their obligation and their legal obligation, and in this policy GA. Does that solve some of the questions on GA? Are there any other questions or concerns with this policy, personnel policies goals?
Thank you, Ms. Minson. The probable cause phrase, so that's a very helpful explanation. I just wanting to make sure if we're putting a policy in place that holds staff to a standard like that they know they have the supports and the training necessary to know, like, where do they go if they aren't sure if they have probable cause or not, if they just have some sort of a reasonable basis for suspicion, how do they know what to do next, I guess is really where I am on this one, is making sure that we're putting in that scaffolding, that framework of training and contacts that they know they can reach out to when they have a concern on this one.
Absolutely. I think that can be included in training, and I know that I have staff members call me, that Dr. Noonan does, that many central office staff are contacted by principals and support staff and others. So I'll make sure that that's part of the training that we make all staff engage in.
Yeah, because clearly we want to be protecting the students and protecting other minors, but also, making sure that we're providing that support for the staff to be able to do that protection and guidance. Thank you.
Thank you, Madam Chair. I just think that probable cause, in addition to the fact that it's the standard for getting an arrest warrant or a search warrant, will leave gaps. And, if there's a potential for connecting dots with reasonable suspicion, that won't happen with probable cause. And so it has the potential to let certain things slip through. And I think that's problematic. And I think the training could try to sort of elide and kind of say, if you have reasonable suspicion,
Right.
please say something.
Yep.
But if that's what we're going to train people to do, why don't we just say that in the policy?
I would be concerned about saying that in the policy because it could impute to the board certain knowledge that's never been reported to the board. So if a staff member has a suspicion or feels uncomfortable or is worried or doesn't know and doesn't do anything about it. And you're right, that's the kind of situation that we would expect that they would report and follow up on. But I think that it is important to align with the Virginia Code and the federal code here for probable cause. And then when it goes through at lines 15 to 30 and talks about those situations in which there may have been probable cause, but you can still give a recommendation or a routine transmission of personnel files if there's been probable cause in order to file a criminal case, but then the law enforcement agency has investigated it and either closed the case or the prosecutor has looked into it and chosen not to charge. That then allows us to say, we've done everything we need to do, we've turned it over, the prosecutor has determined that there is not, that the probable cause that we initially reported that they were going to pursue was not sufficient in order to prevent us from passing along the personnel administrative file or the recommendation. So I think there could always be that little bit of a gap, but I do think it's important for the board's expectations to align with the Virginia code there, because I think we could be opening the board up for liability in another situation.
And how would we open ourselves up for liability? If we say you have reasonable suspicion and the employee doesn't act on that, what would our liability be? If we said do this and people don't do it?
I'm not sure how we would be able to enforce I think having the higher standard of probable cause, and Elizabeth Ewing thought so too, allows us to bring it before me as the attorney and to do research of what do we know, why do we know it, have we let CPS know, have we let the police know, have they been involved, are they pressing charges, having a conversation with the prosecutor of how they're going to pursue it, and we can then call the Commonwealth Attorney and say, is this enough? What do you want from us? Here's all of our records, and they can make that determination. And then we can go back to the staff member and say, thank you for letting us know it's been resolved, or we will take it from here. We'll handle what needs to be done as far as recommendations or anything else. But I think, given the number of staff members we have, given the experiences that we've had in the past, I want to make sure that we're very tight on it. If you're not sure, and as part of our training, you let your supervisor know, you come to Dr. Noonan, you come to me, we will do a full investigation, we will do everything we can to protect our students. But the standard of the board in passing along a recommendation letter of a current or former employee would be, has there been probable cause as established by the law, as required by the federal and the state code, to prevent us from passing along the personnel files or transmitting the administrative files of this individual. And frankly, this isn't going to change anything of what we've been doing in my 2.5 years here and Dr. Noonan's 2 years here. There's never been a situation where we've taken an easy road out. We've addressed these head on.
Ms. Minson, could part of the liability or the opening up to further scrutiny of the school board be the opposite direction, where perhaps a file isn't transmitted because there was reasonable suspicion and it didn't rise to the standard of probable cause, which is in code? And
then we
could
get
that come
into
back into a libel or
maybe defamation,
slanderish
or it doesn't rise to the level and the board is overreaching. There's sometimes staff members who we just don't think have done a sufficient job, but it doesn't rise to the level of having probable cause or thinking that any students are harmed, but it could insinuate, or it could impact an individual's ability to get employment afterwards, and I think that is a possibility.
Okay, but I'll challenge that. I mean, if you have a good faith belief that there is something amiss, as long as that belief is held sincerely and is not done with the prerequisites for
Malice or-
defamation,
right.
then that exposure shouldn't really be a concern, should it?
But then how is that reasonable belief different than probable cause? I think that's where you get into the semantics of, once you talk about the criminal law term of, or the criminal law standard of probable cause, it allows us to then look at case law and see what are other situations where there has been probable cause that are similar to this, and does it rise to that level? And in getting either a Commonwealth Attorney's opinion on it, or making sure that we've reported it to CPS and that our files are available to the police if they did want to press charges, I think, particularly because this is what's required by the Virginia Code and what the other local school boards would be doing, I could see a situation where if we used a more broad term, reasonable suspicion or reason to believe, and then didn't pass along an employee or personnel file, and a staff member, former employee, comes back and says, well, that insinuated that there was probable cause when it didn't rise to that level, and we get into a factual debate of what happened and when, I don't think that I'd rather not be using our resources for that, when, if we get into that situation, I will be very involved, and we'll be working with the CPS, and we'll be working with the Commonwealth Attorney, and CPS will have made a finding of founded or unfounded, and we'll be able to act on that, and we will pursue all those necessary courses that we always have done and will always do. But I do strongly urge that the board keep with the probable cause language.
Okay, I mean, I guess sort of where I end up is this is probably not the right policy to, I mean, if there are suspicions or concerns, those should be transmitted and investigated. If you're getting to the employment referral stage, I assume at that point, if other processes have gone on and there were concerns that were sent on to the Commonwealth's attorney that were, reasonable suspicion, and the Commonwealth attorney said, we don't have enough to go on.
Right.
I have to say, even